Hello, and welcome everyone to HR Options webinar series. My name is Amy Julian, and I am the Vice President here at HR Options, and it is once again my pleasure to be your moderator for today's session. As employers, we face many aspects of liability on a daily basis. We all know that. And periodically, some of the situations that arise will require us to investigate and take action that is critical for us to handle investigations. And it's critical for us to handle the investigations in a manner that will help us contain or reduce our liability. Inappropriate investigations obviously can increase liability, and that's what we all want to avoid and why we are here today. So I've asked my colleagues from Gordon & Reese Law Firm to take us through the best practices involved with investigations. Before jumping into the world of investigations, I'd like to remind everyone that your host for today's webinar, HR Options, is available to employ those contingent workers that you have identified your organization knows they want to use, but you don't want to hire directly. These could be employee referrals or former employees or possibly misclassified independent contractors. HR Options will be the employer of record for those temporary staff for whatever period of time that you need. We also have an amazing group of HR consultants who provide scalable HR support. So please keep us in mind for both contingent employment and HR consulting. Our speakers today, Mark Pozard and Stephanie Wursel, work with Gordon Reese Law Firm out of San Francisco. Gordon Reese is a national litigation and business transactions firm with more than 440 lawyers throughout the U.S., including lawyers admitted in Canada, England, Wales, and Hong Kong. So if you have any needs in any of those areas, you're definitely going to want to give them a call. Mark and Stephanie are going to draw from their extensive litigation background when going through the information that they share with us today to help teach us how to most appropriately conduct our investigations. We're going to go through about 50 minutes of material, and then we will answer any questions that have come in. And you're welcome to send in your questions throughout the session using the text box on your screen. You just type it in, hit send. I'll get those and go through as many as we can. Any questions we can't fit in the time allotted, we will get back to you offline. And with that, that's all of our housekeeping items. I am happy to turn the mic over to Mark and Stephanie to get started. Welcome to you both.
Thank you, Amy.
Thank you.
So we're going to start with a poll that's going to help us tailor this webinar. The one thing that's difficult in doing a webinar is gauging the audience, and we have what appears to be a national audience, folks from around the country. So this is not going to be a California-centric presentation, or at least even though Stephanie and I are based in our San Francisco office, we're going to try to make it applicable to the national audience. And then we also want to get an indication as to whether anybody online has a unionized workforce or an organized workforce. And then also, although I think we know the answer to this, most folks out there, their organizations have employee manuals or employee handbooks, but if there's anybody who doesn't, we'd like to know, because some of what we talk about today will pertain to that. So we're going to take a moment, and Amy, correct me if I'm wrong, but I need to push this so that everybody has a chance to answer.
I believe that everyone should be seeing the unionized. Do you have a unionized workforce? And
okay, so I'm going to give everybody a moment to answer that question, and then a moment to answer whether they have an employee handbook.
Okay, 1 second. And now we're going on to the next.
Okay, so it appears that about 85% of those on the call do not have an organized workforce, and about 15% does. So I will tailor our presentation accordingly, so I won't leave the unionized workforces out of the presentation. And then as to the employee handbook, gathering those results now.
All right, see. All right, and we'll push the results of that. We've got 95% have employee handbooks, so we're good there.
Okay, excellent. So we're going to go ahead and get started. Workplace investigations it's a big topic, and we're going to try to do what we can in about 45 minutes to cover the broad strokes of when to conduct an investigation, and then the best practices for conducting an investigation, and also talk a little bit about what we see as lawyers who often deal with investigations once a matter becomes litigated, and we have to scrutinize the investigation, we have to deal with the results of the investigation, and oftentimes the implications of an employer who doesn't conduct an investigation. Some of the topics we're going to cover, we're going to do very briefly, and some of the slides we're not going to be able to get to, but I believe everybody has a copy of our full presentation, and we obviously will be available after this webinar and beyond to answer any follow-up questions if anybody has them. The first thing we want to talk about is kind of the goals, the overarching goals, and those include why we investigate, why it's important to investigate. There's some pre-investigation considerations that are important to consider with both internal ramifications and external ramifications. Developing an investigation strategy. We'll talk about some witness techniques that we as both investigators, both Stephanie and I conduct internal investigations, have learned that are effective, and then also as litigators and what we find to be effective from those investigations that become part of the lawsuits that we defend. We'll also talk about the final report, which often is the conclusion of an investigation, which often is overlooked. A lot of the HR folks that we deal with, we seem to have seen a trend of in recent times of not completing a final investigation report, which can hamper the effect of a good investigation at any rate, and then also what an appropriate remedial action is. So we're going to start with reasons to investigate.
Okay, and what we're looking at with this slide is determining whether your employees have violated a policy and also whether they have violated the law. Some of you are probably thinking that these are the same things, and in fact they're not. There can certainly be times where an employee has not violated the letter or spirit of the law, but where for various reasons the employer holds employees to different standards. So it's important to investigate not only to determine whether the law has actually been violated, but whether a company policy has been violated. We've certainly seen cases where an employee is terminated because that employee was not following company policy, but that was never documented, and that becomes problematic if the employee files suit. So it's good to investigate to keep that trail to show that employees were either violating the law or violating company policy. It's also incredibly important to investigate to maintain the morale of your workforce. It can be really destructive to the workforce if people are complaining and nothing's happening, and that's especially the case when something is potentially violating the law or violating company policy. Certainly with a situation such as harassment, whether it's sexual harassment or otherwise, if people are complaining and nothing's being done, it's not only unlawful, but it's also really going to harm the morale in your workforce.
And that's something that ties into the next slide, which is, in California at least, there is an affirmative obligation to conduct an investigation when certain circumstances are presented. One alarming trend we see in our litigation efforts in California are the failure to prevent causes of action, which are being litigated with more frequency and sadly with great effect, especially in the San Francisco Bay Area, which is where Stephanie and I practice. But going beyond that, there are affirmative employer obligations on a nationwide basis. In a 2001 case, the Ninth Circuit actually wrote a very poignant opinion, the case of Swenson versus Potter, and I'm going to read the quote. And this is directly from the opinion, and the Ninth Circuit said, the most significant immediate measure an employer can take in response to a sexual harassment complaint is to launch a prompt investigation to determine whether the complaint is justified. An investigation is a key step in the employer's response and can itself be a powerful factor in deterring future harassment. By opening a sexual harassment investigation, the employer puts all employees on notice that it takes such allegations seriously and will not tolerate harassment in the workplace. An investigation is a warning, not by words, but by action.
And certainly in the workplace, that can be the most important kind of deterrent. It's one thing to put a policy in your handbook, but as I mentioned before, if you have a policy in your handbook and employees are complaining about a specific issue and there's no response, then it really renders your handbook meaningless, which employees certainly don't appreciate, and it's also going to subject you to liability, potentially in the long run.
There are other factors, and another trend that we see amongst employers, particularly with the economy, when the economy started going south a few years ago, and when employers started to rehire, they abandoned, and I shouldn't say abandoned, but they lessened their reliance on hiring at-will employees and started hiring more contractual employees. At least in California, with a lot of contractual employees, there are good cause provisions written into the contracts, and in making a good cause finding for termination, there's a pretty infamous case, or famous case, it's called Cotran versus Rollins, that sets the standard for a good cause finding for separation. And that the highlight of a good cause finding is a good investigation. And I'm going to skip ahead a few slides. I think we've covered reasons to investigate and some of the consequences of not investigating, sufficient for our webinar this morning. And we're going to turn to our slide that talks about pre-investigation, and this might perhaps be the most important of the topics that we talk about this morning. And here is why. Oftentimes, employers make the mistake of waiting to investigate until something formal happens, be it a complaint to a manager by an employee or something in writing. And as employment defense attorneys, that is something that we caution strongly against. If you as HR folks receive wind or word of a situation that demands the attention of your offices or your departments, and perhaps even your counsel, you need to take action. Inaction is not sufficient, and if a case that you're working on or a situation you're working on actually develops into litigation, that inaction can and probably will plague your lawsuit.
And, I have to jump in here for a second and just say that I've seen situations where an employee will go to either a manager or an HR person and complain about a specific issue and say, these other 3 people are also having the same issue. And sometimes the response is, well, those people haven't complained to me. And that's going to be really problematic if, whether it's an HR person or a manager, has this constructive knowledge that potentially not only one employee but others are having an issue, and they don't investigate and don't take action to remedy the problem.
One area that we're seeing a lot of activity in, particularly given the volume of employees who have been separated from their employment in recent years, is the exit interview. That is a situation or a time when it's ripe to hear disgruntled employees express themselves. Oftentimes, it's an uncomfortable conversation, but as HR individuals and as departments, we think it is wise and a best practice, if you will, to pay attention and listen. Is there a real complaint there? Is there a real issue there? And not automatically chalk it up to, oh, this is just a disgruntled employee. He or she is just not happy. They're losing their job, and this is why they're saying that. Stephanie and I both have cases where comments were made during exit interviews, and now those are the central themes in the lawsuits that we're handling, because the employer just chalked it up to oh, this is just somebody who's not happy about losing their job, and we don't need to take this seriously. We have the arguments being made by the lawyers on the other side was this was constructive knowledge, and there were pervasive departmental issues that could have been prevented, at least quelled for to some degree, and they weren't, and you had notice of it. And your HR department, what made matters worse is your HR department had notice of it. So we think it is something to pay particular attention to if your organization does partake in exit interviews. And something else to comment on, there's really no buzzword. We've had employers in the past tell us, well, they didn't use the magic word. They didn't say discrimination or harassment or sexual misconduct. I think it's common sense for those of us that practice in the employment and HR worlds, but I think it bears worth repeating that even though somebody doesn't make a formal acknowledgement of a complaint or an issue, that doesn't make it something that you can ignore. So we're going to move on to our next slide. And that is talking about the preliminary steps of an investigation. And this applies whether you are conducting an investigation yourself, whether you are asking somebody within your organization to conduct the investigation, or you've hired somebody outside of your investigation, whether it's a professional HR individual or a lawyer to conduct the investigation. As HR folks, it is incumbent and we think a best practice to identify the potential witnesses as early as possible, especially if you have an organization and take the holiday times. We know that there are parties and there are events where it just seems that bad things happen. And oftentimes during the holidays, there's lots of people who are absent from work. And, take the proverbial Christmas party where somebody drinks too much and decides to be a little too frisky with a subordinate employee, and the next thing you know, you've got a sexual harassment complaint. And as HR individuals, you get wind or word of that. There's a formal complaint or an informal acknowledgement that something happened, and you need to gather the troops, as it were, to figure out, okay, who are the witnesses? Whether you're conducting an investigation or you're going to farm it out, it's important to identify who the players are and make those people available as readily as possible to whomever is going to be conducting the investigation. The same holds true to records and information. We live in a world where information travels fast and furious, and I don't know if anybody else has this practice like me, but I save pretty much everything that comes in to my inbox on my emails, and I compartmentalize them in folders, unless it's your traditional junk mail or something that could never, ever be used again. A lot of people are not like me, though, and they delete matters, they put them in their trash folder, and they empty their trash folder at the end of each workday. If there is something that comes across your desk or your organization, your managers, whomever, it is really important that people are trained and those who are responsible know that keeping those records are vitally, vitally important. Even though there are a lot of mechanisms to recreate and find supposed lost information, it's not fail-proof. And
well, not only is it not fail-proof, but if you're relying on a system to recover documents or emails, it's most likely not going to recover everything. So you can run into a situation where you're recovering emails that are not helpful for your company, but for whatever reason, you're not recovering other emails that could be helpful for you. So it's really important to preserve all of the evidence to the extent possible.
Something that is, I touched on this just a moment ago, and that is part of your investigation strategy, is selecting the investigator. This is one of the most difficult things to do because as fiscally conservative employers, I'm sure most people out there on this webinar take the cost of an investigation, whether it's internal resources or external resources, extremely seriously. And often that's a great thing, but we caution you not to be penny wise but pound foolish. And I have had personally several cases in the last year where I had dynamic HR individuals with whom I worked. They were the smartest people in the room. They knew their processes, they knew the law, but when it came time to testify about what they did and why they did it, they just weren't very good. One of whom was a witness in a trial a case I tried in March of this year, and we were actually in court, in trial, and my HR individual, who had 30 years of experience, came up to me about 2 hours before trial and said, I can't testify. I can't do this. The deposition scared me. I'm shaking. I feel like I'm having a panic attack. You can't put me on the stand. And she was central to my case. She had conducted the investigation where there were claims of sexual harassment and then retaliation. There were other collateral issues, disability discrimination, race discrimination, national origin discrimination, and we had to scramble. And something that my employer pulled me aside later and said, we had a lot of doubts about having her conduct the investigation because we thought that she's incredibly intelligent and competent, but we had a feeling this case would go to litigation, and we had doubts about her in the end, about testifying. And had I known that at the time, I would have counseled accordingly, and I would have advised, hire somebody outside of your organization, hire a professional, hire a lawyer, hire an HR individual who has testimonial experience. And all of those things are critically important to evaluate. Is this something small? Is this something that you think is going to be big and end up with lawyers in court? Other important factors are, is the individual neutral? Oftentimes we ask our managers, go find out what happened. Well, is that manager a drinking buddy with the person who's being accused of harassment? Did that manager just promote the person who is now being accused of discrimination or retaliation? Does the person who's investigating stand on their own in terms of credibility? Did the investigator have a couple of DUIs in the last year, and there's worries that the investigator could have a drinking problem? All of these things are important factors in determining who conducts the investigation. And last but not least, the investigator needs to be trained in how to conduct an investigation. I can't tell you how easy it is for a lawyer a plaintiff's lawyer in a lawsuit to discredit an investigation by discrediting the investigator who didn't have the requisite experience, whether it was internal, external, lawyer or HR professional, line manager, or coworker. If they don't have experience investigating, and you think this is a case that's going to be significant, it could come back to haunt you. Now, moving on to investigation strategy and selecting a framework. One of the most important things to do is, as we touched on before, is gathering and reviewing the appropriate documents. What sets the stage? Let's create the parameters for the investigation. What are your internal policies, procedures? Is the law implicated? And then who are the witnesses that need to be interviewed?
And it's a good idea to review all the documents if you have them prior to speaking with witnesses, so at least you have a general understanding of what's going on. And maybe sometimes that's not always feasible, but it is a good idea to just get a hold on the background documents and the facts before you really start speaking to different witnesses.
And that ties into witness interviewing. Over the course of conducting a number of internal investigations and reviewing those of others, and very competent others, we've come up with some best practices some items we think are best practices in conducting witness interviews. Before we talk about those, it's important to identify what is the end game? What are you trying to gather from a witness interview? We've highlighted several that are on this slide, and that is communication skills. It is important that you address the communication skills of both the interviewer and the interviewee. Oftentimes, interviewees or witnesses, say for example, are not English speaking. English is not a first language. That's a factor that the interviewer is going to have to take into consideration. Credibility. Assessing credibility is vitally important to a workplace investigation. Determining whether the person who is being accused is telling the truth in defending themselves, and whether the accuser is telling the truth in making the accusations. And then, as the slide indicates, interviewing the complainant, interviewing the accused, and other witnesses, that's really an identification of who your target audience is.
And when you're interviewing witnesses, it's really important to remember that oftentimes you're speaking with people who are really hesitant to become involved in these situations. This is their livelihood, and people are often worried that they're going to ruffle the wrong feathers or get involved in office politics that they don't want to become involved in. So it's really important to be a good listener and to really learn how to elicit information from people who might not want to say anything. And I've seen this firsthand with people where it's clear that they're thinking that there's something they might want to say, but then they doubt themselves and they don't say it. So you really do have to learn how to pull information out of people and really not just accept what they're saying if you think there's something beyond that, and get them to feel comfortable and know that whatever they say, it will be taken seriously and that they won't be the subject of retaliation.
So those of you looking at the slide, I think all of you know the W's and the H, the open questions, who, what, when, where, why, how, but I imagine a few people online don't know what the O is. And the O stands for others around. The O is very important in an investigation because we need to identify other witnesses. You may not interview other witnesses necessarily, but we need, as I mentioned before, we need to gather the scope, the full scope of who is involved in a situation. And then you can identify who you need to interview or conduct follow-up interviews with from the O. A few recommended practices in terms of interviewing technique are ask open-ended questions, encourage narrative responses. Too many times we see interviewers who ask questions like lawyers. They ask questions such as, didn't you do that, or when were you here? When you were there, you did this, leading questions. And that's not a particularly, we have found, that's not a particularly effective interviewing technique when talking to witnesses or talking to folks who are accusing or being accused of wrongdoing in the workplace. By asking open-ended questions and encouraging narrative responses, you are also building rapport. You're listening, and that is one of the key components of a good investigation, is listening, finding out information, and not directing that information. Another important factor is asking baseline questions first. Baseline questions help you evaluate credibility. It allows you to ask the same questions of everybody with whom you're talking. And it allows you to get a judge or a take on an interviewee's demeanor. Are they going to be defensive? Are they going to be collaborative? And then lastly, we have found it more effective to ask the threatening questions last. The million-dollar questions are usually, did you grab her backside? Did you punch him? Did you retaliate? Those are questions that we have found, and we have actually seen, when asked first, are not very effective. So our suggestion and recommendation is to ask those types of questions after you've built a rapport and gained the trust of whomever you're talking to. Something else that's important in the witness interview is asking follow-up questions. Too often we have those questions that linger in the back of your mind, and we say, should I ask it, should I not? What are the ramifications? Err on the side of caution and ask it, because you might not get another chance to ask that question. And if it's something that's troubling you, ask it. Or at a minimum, get the advice of somebody senior to you or somebody outside of your organization, an HR expert, consultant, your counsel, but don't just walk away and not do anything with it. If there's a question you think you need to ask, a follow-up question, then take the steps necessary to ask it or follow up with it. Also ask questions that are designed to elicit information pertinent to somebody's motive. Sometimes motives are pure, sometimes they're not. And as lawyers, that's something that we look very carefully at, is what is the motive? Is somebody filing a lawsuit because they want money? Do they want to exact change? Are they doing this to get somebody fired? Is it a revengeful tactic? But oftentimes, before we even get to that, we can find out motive. And as HR experts and individuals and practitioners, you guys are on the front lines of finding out the motives. One more comment on this slide. Contradictions are important and should not be overlooked. A lot of questions that you may ask in an investigation, whether of the accused, of the accusor, or of witnesses, are going to lead to inherent contradictions. And in a good investigation, you're going to embrace and follow up on those contradictions, find out why. What motivated the contradiction? Why is there a contradiction? And those are things that should also be addressed in the final report, which we'll get to in just a little bit. On the next slide, we talk about communication skills, and our headline is that witness interviews are essentially more than just a conversation. This is a formal process. It's not an informal thing necessarily. particularly in your significant issues, a workplace investigation is a designed process. And if you are an investigator, we think it's important to establish with whomever you're talking to that you are the investigator. You're not their friend. You're not just their colleague if this is an internal investigation, but your role on that particular day in that particular moment is as an investigator, and it's important to explain that. It is important to emphasize the importance of full answers, and what we mean by that is the person who says, yeah, I heard something about that, but I don't want to talk. Well, it is incumbent upon whomever you're interviewing to explain, to give you the full answer, and to follow up on that. Something else that we have found troubling when dealing with workplace investigations is the promise of confidentiality. I'm pretty confident that almost everybody out there who has been involved in a workplace investigation, either as an investigator or supervising one or making one come to fruition in whatever manner, has dealt with the promise of confidentiality. Either somebody you're talking to or one of the witnesses says, this can't go any further than me, and in order to build rapport, the investigator says, yeah, this is confidential, it's not going to go any further than me. That we have found is a mistake. You can't promise confidentiality because if the findings reveal something that has to be dealt with or becomes part of a lawsuit or a claim before the EEOC, it won't be confidential. And you have then promised something to build an immediate rapport that you're not going to be able to deliver on. What you can, however, not promise but offer is we will keep this as confidential as possible, but we can't promise absolute confidentiality. We have found in reviewing and drafting employee handbooks for employers who have somewhat antiquated handbooks or policies is that there are policies out there that promise confidentiality, that offer confidential mechanisms for, for instance, a hotline. Your complaint will be confidential. We find that to be a mistake because you can't promise absolute confidentiality. If there is a complaint that is made through, for example, a hotline that you have to take action on, it's an inherent conflict of promising confidentiality, but at the same time, you're following up on that. Now, granted, this is a very broad stroke commentary, and there are definite ways, particularly dependent upon the laws in your state, that you can tailor hotlines or, partially confidential hotlines or mechanisms that affect the same purpose but aren't necessarily as draconian as the absolute confidentiality provisions that Stephanie and I have both dealt with.
Now, for purposes of internal interviews, something that, obviously, as Mark said, you can't promise confidentiality completely, but you can offer to keep things as confidential as possible. And what will sometimes make witnesses feel more comfortable with that is discussing the anti-retaliation policy of your company. Because sometimes it is a worry by the employee that if they say the wrong thing, that they'll be retaliated against. So while you can't promise complete confidentiality, you can at least promise that they won't be retaliated against in any way for whatever they might tell you.
And moving on to the next slide, and it's along the same theme of more than a conversation, there's a few points that we think are important to point out, and those are interviews should often be done privately, meaning not in an open workspace. If you have an employee who sits at a cubicle, don't conduct the investigation at their cubicle where others can hear what is being asked and answered. Do it in the privacy of a room, perhaps with no windows, so that people aren't walking by going, why is Sally Smith sitting in an interview with the Director of Human Resources and our corporate lawyer? Another consideration is consider the order of interviews. Who are you interviewing first and why? One very important and perhaps the most important takeaway from this slide is contemporaneous documentation. I can't tell you how many times we have seen very good workplace investigations performed, but the documentation comes weeks or months, sometimes years later. And that essentially defeats the purpose of the investigation and casts doubts on the integrity of the investigation. So if an investigation is worth conducting, it's worth conducting it right, which means documenting as expeditiously as can be done. The next slide, we want to address a topic that is very difficult and often uncomfortable for investigators, even experienced investigators. And this ties actually nicely with the slide we talked about a few moments ago in determining who to conduct the investigation. It is important, whomever conducts an investigation, particularly an investigation that is of, when you're dealing with serious issues or serious claims, and we have found in the cases of sexual misconduct allegations, this is ever more important, and that is assessing credibility. It is hard, inherently hard. It's a human factor to look at somebody and judge whether they are being truthful or not. Our juries are asked to do that often, and it is one of, listening to a lot of jury experts and working with a lot of jury consultants, that's the hardest part about being a juror. In effect, as an investigator, you are a juror. You are a judge. You are judging whether somebody is telling the truth. And there are a lot of factors that go into that. And the first and kind of the threshold factor is, is the person who is investigating, can they make an assessment of credibility, especially if it's an internal investigation and this is somebody who you have worked with and perhaps you know their family. I think we all are aware, at least anecdotally, of the person who is accused of sexual harassment, but he's been working for the company for 25 years, and he's a family man, he's happily married, he's got 2 beautiful kids, and he would never do that. Those are judgments that your investigator can't have color their investigation. They have to judge the integrity of the whole investigation in and of itself, and they have to be able to judge the credibility of the accuser and the accusee. Part and parcel of judging and assessing witness credibility is observing demeanor. The nonverbal cues. Is somebody fidgety? Are they nervous? Why are they nervous? And this is where the baseline questions come into play. If you ask the same people the same basic questions at the beginning of an interview, that helps with judging credibility. And most importantly, when you take notes or when your investigator takes notes, it's important that they document those comments. To tie back into what Stephanie and I do, when I take a deposition, and I've probably taken 1,000 depositions, regardless of who I am deposing, whether it's a witness or a plaintiff in a lawsuit, I write down notes as I'm going along, excited, happy, defensive. I am judging credibility of the people I'm deposing, which is no different than if I'm conducting a witness interview or conducting an interview and an investigation, and whomever is conducting your investigations needs to be doing the same. Other ways of assessing credibility that we have found to be the most important topics or the most important categories are memory, truthfulness, corroboration, possible bias or actual bias, consistency, and prior misconduct. And we can talk offline about those topics because each of those probably are worth about 5 to 10 minutes of conversation, and we just don't have time for that today. So moving on to the next slide. these are some general overarching themes to witness interviews and interviewing the complainant.
So it's really important to obviously interview the person as quickly as possible for a number of reasons. First and foremost, you want the complainant to think and understand that their complaint is being heard. So you don't want to have a situation where someone's complained and then they never hear anything about it for days or weeks. You really want to be able to follow up with that person quickly. It's also important to actually confirm your understanding of what the complainant is telling you. And that's just part of active listening, and it's something that you really have to practice. And, you know, I find that you can practice it in everyday life, and people never know you're doing it. And part of that is just relaying back what you've heard to confirm that you're understanding it correctly. And it's really surprising how often you will do that and hear, no, it's not exactly right. It's that, but it's also something in addition. And you'll get additional information by just relaying back what you've heard from the complainant, and it really makes your investigation more thorough. You also, we hit on this a little bit earlier, but you really do want to use open-ended questions. Because if you're using questions that just have yes and no answers, you're really not getting the full scope of what happened, and you're actually inserting your own knowledge into that situation. You're assuming that things that you've heard are correct, and in some situations you can even be sort of directing the complainant as to what they should or shouldn't say, and you really want to avoid that. So ask open-ended questions where the complainant is free to explain in a narrative what has really happened.
I'm scrolling, well, Stephanie was talking, I was scrolling through the questions, and there are a lot of them, and that is one of the difficult things about a webinar is that we can't really address all of the questions in this forum, and that's one of the things I love about the HR community is the ability to roundtable. One of the questions that I noticed that I think we can address is the question about recording. And we think it is a good idea to record interviews. Now, that comes with a caveat. You can't do it secretly or clandestinely. It has to be open and obvious, and one of the practices that we recommend is asking the interviewer, or telling the interviewee, we would like to record our conversation so that there's no mistake as to what anybody said, and may we have your permission to do so. And then you start to record the conversation, and then once the recorder is on, you go through that same back and forth. And you get permission on the recording, and you preserve the recording. I have a case right now where the case hinges on what my CEO said to a key employee. He recorded that conversation on his iPhone, and he dropped his iPhone in the kitchen sink. And the recording is gone. And now it is the proverbial he said. The employee says one thing, my CEO says something different. We'll never know. And now, ultimately, it's up to a judge or a jury to decide who is telling the truth. So if you do make that recording, make sure you preserve it in at least one additional place other than the recording device. And then also something to be aware of, the interviewee, with all of the smartphones out there, I think pretty much all of them either themselves can become a recording device, or you can download an application that allows it to become a recording device. If they're recording it, ask them to provide a copy to you. And make sure you know that they're recording it, because they have the same obligations. At least in California, you can't secretly record a conversation, and if an interviewee is secretly recording a conversation, they can get into trouble. So if you notice or have a suspicion that somebody's recording a conversation or recording an interview, don't let that pass. I would address that head on. Moving to the next slide,
And Mark and Stephanie, I just want to make sure that you're aware we've got a little less than 10 minutes, so I'm not sure if you want to try and pick out some of the key aspects of the remaining slides and then go to questions. Whatever you'd like to do is fine with me.
We are doing just that.
Okay.
So in talking about this next slide, this is the key elements to interviewing that we have found to interviewing the accused. Whether it's a big issue or a small issue, it is human nature to become defensive when something uncomfortable, if not illegal, is being brought to your attention. We think it is important to indicate to the accused, whether it's an internal or an external investigation, that no decision or conclusion has been made. We are giving you the opportunity to tell us your side of the story.
And that's really important because, with the complainant, you are going to be open and you're going to try to be eliciting information from them. And you don't want to approach the interview of the accused person as though you've already made a decision. Because just because there's an accusation doesn't mean that it's truthful. So it is really important that the person who's being accused feels that just because an accusation's been made, it doesn't mean that they've already been sort of convicted in the company's mind. And oftentimes there are explanations. So you really have to be sure that you communicate that to the person that's accused when you're speaking with them.
And 2 points that aren't necessarily on this slide that I think are worth mentioning. The first is it's important to give a full opportunity to the accused to respond to everything he or she is being accused of. Sometimes there are multiple allegations. Take, for example, a complaint of sexual harassment and then retaliation, and some people might think, oh, I've got to focus on the sexual harassment, but they give short shrift to the retaliation. It is important, whomever is conducting the interview, allow the accused to address everything, the full 360-degree focus of whatever the issue is. And then last, it is, and this is something that whomever is conducting the interview might not have on the front of their mind, but certainly should in the back of their mind, and that is how that interview is conducted could have effects beyond what actually brought that interview to fruition. And what I mean by that is, if an interviewer is somebody internal, say a manager, and the interview is conducted with some hostility or some doubt or even sarcasm, the accused later is found, and here's my hypothetical, the accused is later found to have done what he was accused of. I'll use a male example. And he's angry, and he thinks, I had no fair chance. The mind was made up by my interviewer before he got in that interview, and I was toast. I didn't get a fair shot. Well, I want my fair shot in court. How an interview is conducted is often as important as what transpired, what questions were asked and what information was learned. Because an untrained interviewer or investigator can alienate somebody to the point that even if they don't have a valid claim that it was, what they did was proven, anybody can go down to the courthouse and file a lawsuit, and if it's an employment-related lawsuit, it could be, it falls on the heels of an EEOC or in California, Department of Fair Employment and Housing charge that costs nothing to file. And your company is then defending a non-meritorious lawsuit that's going to cost you $5,000, $10,000, $15,000, $20,000 to be right. All of that could have been avoided with an appropriate interview at the appropriate time.
Well, Mark and Stephanie, I think what this has shown me is that we need to schedule an hour-and-a-half session, because not only am I cutting you short from finishing your discussion about all of the things that we need to know about investigations, but we have just a few questions that I think are really critical and can be helpful, and so I want to get to those, if that's all right with you.
Let me just make one quick comment, and this is about concluding the investigation, and that is your investigation or whomever is conducting the investigation for you should be put into writing the results. It's not enough just to do the investigation. It needs to be documented afterwards. And it is our preference and our recommended best practice that the investigation reports be a standalone document and not necessarily put in somebody's personnel file. And there's a lot more that goes into that, so I apologize for the brevity, but I did want to throw that out there because it brings this whole thing full circle.
Okay, great. There was one question that I thought was really relevant, and that's if a company is using an external investigator, should the report be sent to counsel for client to establish that client privilege, or should it be sent to the company, whoever that's the HR manager, claims whoever's the point person there?
Honestly, it depends, and I have done it in all different ways. I have done it where where the employer hires me to then hire the investigator who conducts the investigation at my request, and I get the report, and then I disseminate the information to the employer, and we protect the attorney-client privilege. It really depends. What is the end game? If it's a bet the company issue, I think the privilege is important. If you get a report back that is, for example, I dealt with a case where there was a whistleblower, an FDA whistleblower, there was a key TAM related action, and we wanted to, and the Department of Justice was involved, and it was an enormous case. And we had, the way the investigation was tailored, it was done in such a way that the privilege was preserved throughout, and that was by necessity. Now, at other cases, I've had a sexual misconduct case where we had a terrific outside investigation that we absolutely wanted to use, and so we didn't do anything to preserve the privilege because we knew what we were going to find, and we wanted it to be open and obvious, and it was. And so we didn't do anything to protect the privilege.
So perhaps when in doubt, go through counsel.
Yeah, I would presume that everybody on this call has either corporate counsel that works, in-house counsel or counsel outside that they have at least worked with in the past, and have somebody they can call to round table that with, or at least they can find a competent employment lawyer who can walk through those issues with them. I do that, once a month with my client and we've got about 25 employment lawyers in San Francisco, and we probably do that once a day, if not once a week, with our body of clients, because it is that important.
Okay, great. Should every person that you're going to be interviewing in a specific case be asked the same questions? The baseline questions, yes. I think, and we didn't cover this in detail, but you need to tailor your investigations, or I take that back, tailor your interviews to the interviewee. Of course, you're not going to ask the accused the same questions you're going to ask a recipient witness. But baseline questions, yeah. Do you know so-and-so? How long have you known so-and-so? Do you have any experience with this department head? What is your experience with this department head? Baseline questions such as that should be the same. Okay.
Or as simpler as they can be.
Okay, great. And the last question is, what information should be provided to the complainant following the end of the investigation? Is it appropriate to talk about disciplinary actions that other parties received, or? I'm going to give a very broad brush answer to that because it's state specific. In California, I think it's a little bit different than other states. I could be wrong, but as a general practice, we recommend not sharing the results or the disciplinary matters that are meted out to an accused with the accuser. And that is because an employee has a right to privacy in their employment. And personnel actions often are considered a matter to which somebody has a right to privacy. And so telling them, I think you can tell them the matter has been handed and discipline, the appropriate level of discipline has occurred. Now, if somebody is fired over it, that's obvious. If somebody is suspended for a week, that's obvious. But
I don't think it's a good practice to tell the accused, for example, or the accuser, for example, Jimmy Johnson was suspended for a week without pay.
Oh, Mark, I'm sorry. I have to cut you off here. We are well over our time. I want to thank you and Stephanie so much for your time today. Obviously, this was too short a period of time. I want to let everyone know we'll get back to you offline with answers to your questions. And I do want to thank everyone who joined us today. I'm sorry for the short time frame we have, but that's it for today. We'll see you all online at our next webinar. Bye-bye.